This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Morgan McKay Davenport. It's case number 2023 CR 68. I'm trusting that the female individual shown from the Greenwood County Jail's location is Morgan Davenport. Is that correct?
Yes, sir.
Thank you. Blake Cooper appears as defense counsel, Jill Gillette as Greenwood County attorney on behalf of the state. This matter comes before the court at this time for arraignment. Mr. Cooper, does your client desire the charging document to be read to her?
No, Your Honor. We would acknowledge receipt of the complaint information, waive its formal reading, enter plea of not guilty, and request a jury trial setting at this time. We're still working on the case, Judge, but let's go ahead and set things at this point.
All right. Setting things at this point means that the jury trial will be scheduled for Tuesday, November the 28th, starting at 9:00 a.m., continuing day-to-day thereafter until complete. Again, that's Tuesday, November the 28th. Counsel, I have very limited dates available for either pretrial conferences, status hearings, plea hearings, or anything that might be related to this case. I will attempt to set something the week before. Counsel, I'm offering at this point 9:30 a.m. on Wednesday, November the 22nd.
And I can do that, Judge.
Right. The Davenport pretrial conference is currently set for 9:30 a.m. on Wednesday, November the 22nd. That will be by Zoom. Obviously, the jury trial, if it goes, will be in person at all stages.
Judge, could we take up a bond on Ms. Davenport as well, please?
Have you filed a motion, Mr. Cooper?
Judge, we had contacted your office and was told that we could take it up that date. I did not file a written motion. I had tried to talk to Ms. Gillette about this last week. But no, there isn't a written motion on file.
You may address the issue.
Judge, this is a situation in which we had an arraignment date scheduled on August 3rd of 2023. Ms. Davenport was not available at that time, did not appear at that time. Although she had appeared at every other hearing we had on time. I explained to the court that I was surprised because she had been very involved in her case. Judge, we tried to get a hold of her later that day, not too long, frankly, after the hearing. Ms. Davenport contacted our office and said she had been having trouble with her phone, that she had overslept, and that she was very sorry. I then contacted Ms. Gillette by email to let her know that, as my notes reflected that the state would hold off on a bench warrant for a little while in case we were able to contact her. I was informed that this was no longer the way that things would be handled, that our office was, this was happening to our office apparently too often, that our clients were calling in a little bit later. And so a bench warrant still issued, and Ms. Davenport, we informed her that she would have to turn herself in. It took her a little while to take care of things with her child. She has a 3-year-old child who's now in the care of her mother. On August the 28th, Ms. Davenport turned herself in at the jail. She lives with her mother in Leon, Kansas, Judge. She's a CNA. She has a child of 3 years old whose mother has been taking care of the child for approximately 31 days at this point in time. This case, regardless of outcome, will be presumptive probation. I'm asking, Your Honor, that she be OR'd again. I think Ms. Davenport has learned her lesson at this point in time. She is not a flight risk, and so would ask the court to OR her today, please.
perhaps not a flight risk, Mr. Cooper, but certainly she's unreliable when it comes to showing up for court. We try to allow people to have flexibility to participate in Zoom proceedings, even from remote locations. It's easier to appear for a criminal court than ever before. And then when people don't do it, I take that as their refusal to work with the system. And the court entered an order of bond forfeiture, bench warrant, and no bond hold. At least at this point, Ms. Davenport can be available for court each and every time, because the Greenwood County Jail has an excellent track record about getting people before the court by Zoom when scheduled. When they are not in jail, the track record is not so good. Ms. Davenport has had the opportunity to demonstrate that she can be trusted to appear in court on her own on bond, and she hasn't availed herself of that opportunity. Now, with those observations made, does the state even take a position here, Ms. Gillette?
Judge, she's been in 31 days, and I hope that she has learned to be here on time for court.
I promise. It won't happen again.
Well, here's the other thing, counsel. You talk about how there's been some discussion about resolution of the case. We're no closer to resolving this case than we were before. This case is going to be set out to November because a jury trial has been demanded, and she has that right. There's no question about it. But I would think that if she was interested in having the court review her situation, the court might look at the situation differently if the case was resolved and disposed of in some way. Right now, we've just got a pending case, and I have to trust her not only to show up for pretrial conference, but also for jury trial. The court has considered the request.
Judge, I will tell you, we have certainly on our end, I don't like to get into these matters, but we have attempted that on our end.
Okay.
I'm simply waiting for a response.
We're simply not convinced that Ms. Davenport's a good risk to let back out into the community when she's failed to appear in the past. This is a felony case. I take your appearance requirements very seriously, Ms. Davenport. I'm not inclined to reinstate your bond. Again, I think you're a poor risk to reappear when you haven't appeared for an important court proceeding in this court before. You're not necessarily entitled to a second chance, and I'm not inclined to grant one. So the oral request for bond modification is denied.
Judge, would you set a bond of some kind?
No. No. All right, we've got our pretrial conference established in November. We've got our jury trial established in November. Bond modifications denied, or status remains the same at this current time. Ms. Gillette, was there any other case-related matter that we still need to address here today?
Not from the state, Your Honor.
Mr. Cooper, anything further at this time?
No, Your Honor.
Very well. Then the Davenport matter will be in recess, and this